So let's take a look at some actual law here. Let's see, is this Florida? That's Florida. And by the way, this is from our Law of Self-Defense, Florida specific self-defense course that you can access online. You can purchase the DVD. Learn more about that at lawofselfdefense.com/state. We have state-specific courses for all 50 states. This is just a portion of that course that deals with defense of property. Defense of property. I just pulled it out for purposes of this show. So, generally speaking, in every U.S. state except for Texas, but in all other 49 U.S. states, you can only use non-deadly force in defense of personal property, like a cell phone. Someone's trying to steal your cell phone or an unoccupied car. You can only use non-deadly force in defense of property. Texas does have a provision for using deadly force in defense of even mere personal property. You got to jump through quite a number of hoops there, but it's the one state that at least has some provision for the use of deadly force in defense of mere personal property. But for our purposes, let's presume, if we're just talking stuff, only non-deadly force. But every state also has a provision for the use of deadly force in defense of what I call highly defensible property. And this always includes your home, including temporary homes. Like if you're staying in a hotel, so your home is your castle. If you're staying in a hotel, while you're staying there, it's your castle. If you own an RV, while it's in storage, it's just personal property. But while you're living in it on vacation, it becomes your castle, highly defensible property. If you're camping in a tent, when your tent's folded up in the bag in your basement, it's just an item. It's just personal property. But when you're at the campsite, you're living out of your tent, that becomes your castle. That becomes highly defensible property. And the key distinction between highly defensible property and personal property is that highly defensible property has as a purpose the shelter and protection of people inside the property. Obviously, just items don't do that. So that's why, for example, by the way, a car that has no people in it is treated as personal property. In most states, you can't use deadly force in defense of personal property. But if there are people in the car, then an effort to take the car goes from an auto theft to a carjacking. And now the car is serving as highly defensible property, providing shelter and protection for the people in the property. And now, as highly defensible property, you can be justified in the use of deadly force in defense of that occupied vehicle where you would not be in defense of the unoccupied vehicle. Jennifer says she likes her personal property. I get it. Listen, I'm not making a moral judgment here. I'm just describing what the law is. 49 states say if it's personal property, you are not allowed to use deadly defensive force in the absence of some threat to persons. Does their law have to be that way? Could every state adopt the Texas approach that does allow for the use of deadly force in defense of personal property under particular circumstances? Yeah, every state could do that. There's nothing unconstitutional about the Texas law that lets you shoot someone because they stole your phone under the right circumstances. Every state could adopt that law. Maybe every state should, but that's a public policy discussion. I can only describe for you what the law actually is. So, personal property, no deadly force, but highly defensible property, you may be able to use deadly force in that circumstance. So I've already described the distinctions between personal and highly defensible property. Here's that presumption of reasonableness I was telling you about. This is Florida Statute 776013 that deals with home protection and creates the presumption of reasonable fear that I've just described. So in Florida, if you're in your home and defending yourself against an intruder, they create a legal presumption, and the jury is told this. It is presumed that they had a reasonable fear, that homeowner, of imminent death or great bodily harm. They had a reasonable fear of imminent death or great bodily harm. Now, there are conditions that have to be met. The person entering has to be entering not just unlawfully, but also forcibly. The person who's defending has to know at the time, you can't have discovered later that it was an unlawful and forcible entry. But the point for us is this legal presumption that's created that you have an imminent fear, you have a reasonable fear of imminent great bodily harm, death or great bodily harm. Think about what that's doing for you. Think about what that's doing for you. Remember this slide? the 5 elements of self-defense: innocence, imminence, proportionality, and reasonableness. That Florida presumption of reasonableness statute is creating a legal presumption that you had a reasonable fear of imminent deadly force harm. Well, that's effectively giving you 3 of these 5 elements, right? A reasonable fear of imminent deadly force harm. Deadly force is the proportionality element. 3 of the 5 elements you need to be justified in the use of deadly force against another human being, even to the point of killing them, are given to you by Florida and many other states in the U.S. if you're in your home and defending yourself against an unlawful and forcible invader. That means these are no longer targets of attack for a prosecutor. A prosecutor cannot argue to a jury, well, the threat wasn't imminent, or the threat wasn't deadly, or the defender's perception of the threat was unreasonable. All that's off the table. Now the prosecutor doesn't have 5 targets of attack to try to destroy your claim of justification for your use of deadly force. He's only got 2. And in fact, he doesn't really even have 2. Because remember the Castle Doctrine? The element of avoidance only says that, well, if you're out on a public street and you could safely retreat before you use deadly force, you're required to do that. Only 11 states impose that anyway. But even if you were in one of those 11 states and would have had a generalized legal duty to retreat before you could defend yourself, every state, including those 11, has the Castle Doctrine. What does the Castle Doctrine do? It relieves you of that otherwise existing legal duty to retreat before you can defend yourself in self-defense. It, in effect, takes away that element of avoidance. Now, of the 5 elements of self-defense, between the legal presumption of a reasonable fear of imminent deadly force harm and the Castle Doctrine, 4 out of 5 of the elements are removed as targets of attack for the prosecution. That is pretty awesome. The only one left is you can't have been the aggressor in the confrontation. Just because you're in your home doesn't make it an arena for combat in which you can start a fight, right? Makes sense. But in a real home invasion scenario, you're in your house, someone kicks in your door. Isn't innocence kind of baked into the cake? Who was the initial aggressor in that confrontation? Obviously, it wasn't you. You're just sitting at home. It was obviously the person who kicked in the door. So you have the element of innocence too. So the home invasion scenario under American law, for most states, the states that have this legal presumption, it's almost impossible for the defender to screw up the use of even deadly defensive force against that home invader. You're given everything that you need to be justified in that use of deadly defensive force. Now, people do manage to screw it up. That's why it's only almost impossible to screw it up. People do things like scare the invader away and they chase the invader down the street and shoot him. That's no longer a defense of highly defensible property, a defense of castle scenario. You may wish that the law allowed you to do that. I can certainly understand that from a moral perspective, but that's no longer a home defense scenario. The person in the home may not actually be an intruder. That can also be an issue. So most of these legal presumptions require that the intruder be both unlawfully present and have entered forcibly. Unlawful and forcible. In fact, we can see that, I believe, in Florida statute. Let's see. A person is presumed to have a reasonable fear of imminent peril of death or great bodily harm when they're dealing with someone who unlawfully and forcefully entered the home. See that there? First couple of blue words, highlighted words. Why do they require both? And not every state does require both, by the way. Some states, just unlawful is enough. But most states that have this legal provision do require both unlawful and forcible entry. Why is that? Well, because there could be innocent reasons why someone is unlawfully in your home. That may be hard to believe, but it actually happens with some frequency. An example of that, for example, could be a repairman who's sent to the wrong address. He's sent out to fix somebody's dishwasher, and he's told, listen, the homeowners have to work. They can't be at the home, but they're going to leave the back door unlocked so you can get in and fix the dishwasher while they're not home. And they give him an address, and it's the wrong address. So he goes to the wrong house. He goes to the back door. The back door is unlocked. He walks in. He's not there lawfully. He's unlawfully entered that home. It's an innocent mistake. He thinks he has legal permission, legal license to enter the home, but in fact, he does not. In fact, he's trespassing. He's there without license. So he's present unlawfully. But here's the key. And by the way, another scenario this happens. Many of us have lived in these giant apartment complexes, right? Where every apartment pretty much looks the same. And of course, you know which apartment is yours. But what if you have guests from out of town? And they're staying with you at your apartment. They go out, they have a few drinks, they come back, and they walk into the wrong apartment. Completely innocently. Happens all the time. Now they're unlawfully present in that apartment. But just like the repairman sent to the wrong address, while they're unlawfully present, they're not present with malice. They're not there to commit some crime. It's an innocent intrusion. They're innocent intruders. They're not malicious intruders. So there may be an innocent explanation for why someone's in your home, but there cannot be an innocent explanation for why somebody broke something to get into your home, right? The repairman's not going to kick your door in. The out-of-town visitors are not going to smash a window to get into your apartment. So by adding the condition of forcible entry, the legislature has removed this possible ambiguity around an innocent intruder. So that's the legal presumption of a reasonable fear of imminent death or serious bodily injury if you're in your home defending yourself from an unlawful and forcible intruder. Some states even go further. So keep in mind what this legal presumption of reasonableness is doing for you. It's not literally saying these elements aren't required. It's saying they're legally presumed to have been met. In particular, that element of proportionality. So normally you cannot use deadly force in self-defense or defense of your home unless you're facing a deadly force threat. That's proportionality. Can't use deadly force unless you're defending against deadly force. And what the legal presumption of reasonableness does is it presumes that you're facing a deadly force threat. So it's not eliminating the requirement of proportionality. It's simply saying we're going to presume that proportionality has been satisfied, that you are facing a deadly force threat. Some states go even further than that. Colorado does something different than this legal presumption. And this is the statute we're going to look at is famously or infamously referred to as Colorado's Make My Day law, from the Clint Eastwood movie, where he points his gun at the punks and says, "Make my day. I dare you to try to shoot me." It's a stupid name for this statute. But this statute does something remarkable because it doesn't just presume that the element of proportionality has been met. It removes the element of proportionality. And it also does not require a forcible entry. A mere unlawful entry is sufficient. And this justification exists even if the homeowner is just presuming what the intent of the intruder is. It's arguably the most robust defense of castle statute in the country because of those factors. So it's statute 181704.5, use of deadly physical force against an intruder. And it reads, any occupant of a dwelling. So you don't even need to be the homeowner. So this can be an issue in defense of homes because sometimes the special legal benefits given to a home defender only apply to the owner of the home. Like there are castle doctrine laws. Remember, castle doctrine says that if you otherwise would have a legal duty to retreat before you can defend yourself, you're relieved of that legal duty to retreat in your home. Okay, fair enough. But in many states, they say, but that benefit only applies to the home owner. So you have castle doctrine privileges. You're relieved of the otherwise existing legal duty to retreat when you are in your castle. But if you're a guest in someone else's castle, they have castle doctrine privileges. They're relieved of the legal duty to retreat. But as a guest in their castle, you are not. You would still have a legal duty to retreat if you otherwise would. The same as someone's a guest in your home. You're in your castle, you have castle doctrine privileges, but they're merely a guest in your home, they would not. Now, not every state does that, but some states do. They condition castle doctrine on being the castle being your castle. So Colorado's Make My Day statute doesn't require that. It doesn't say the owner of a dwelling. It says the occupant of a dwelling. You're personally present in the dwelling. Is justified in using any degree of force, including deadly physical force, against another person when that other person has made an unlawful entry, does not have to be forcible, doesn't say forcible here, They just entered unlawfully. The door could have been unlocked and they just opened the door and walked in. They didn't have to smash anything or break anything. They made an unlawful entry into the dwelling, and the occupant has a reasonable belief that that intruder has committed a crime in addition to the entry. So they're there to commit a burglary, for example, or an offense against some person, or is committing or intends to commit a crime. Well, how would you know if someone intends to commit a crime? Isn't that just kind of mind reading? Isn't that giving an enormous amount of discretion to the homeowner? I mean, I think that's great, but that's what it's doing, right? You're justified if you believe that this person you're looking at intends to commit a future crime. Great, awesome. So if you reasonably believe they've committed a crime, some other crime other than in addition to the entry, or intend to commit a crime in addition to the entry, and they threaten you with any physical force, no matter how slight, either you or any other occupant in the dwelling. What this particular language is doing is completely obliterating the element of proportionality. It's not presuming that they presented a deadly force threat to you. It's saying we don't care. It's not necessary for your justification of deadly defensive force that they presented a deadly force threat. They don't have to actually be doing it. You don't have to reasonably perceive a deadly force threat. We're not even going to require a legal presumption that it was a deadly force threat. If they threaten you with any physical force and you meet the other conditions of the statute, you can just shoot that person. They could threaten to poke you in the chest with their fingertip, and that would be enough to justify deadly defensive force here. No proportionality required. It's pretty cool. I expect the liberals in Colorado to get rid of that provision pretty soon, by the way. The liberal prosecutors have worked very hard to limit this statute as much as possible. For example, we had a case not long ago, a few years ago in Colorado Springs here, where a homeowner lived in a home and had a garage, but the garage was not attached to the home. It was a detached garage, and someone was in the garage stealing stuff. Colorado Springs is a crime-ridden hellhole. So the homeowner gets his guns and goes out to his detached garage, is confronted by the thief inside the garage, shoots the thief, and tried to raise this provision, make my day, defense of castle, as a legal defense to justify the shooting. And the prosecution argued, and the court agreed, and this was affirmed on appeal, that a detached garage is not part of your dwelling for the purpose of this statute. If the garage had been attached to his house, it would have been different. So the statute doesn't say that. The statute doesn't say a detached garage is not included. That's an interpretation of a court, affirmed on appeal. But that's the law now in Colorado.